Hi everyone. Today I am going to cover the case of Aruna Ramchandra Shanbaug versus Union of India and others 2011. Aruna Shanbaug, a 25-year-old woman from Karnataka who was working as a nurse at King Edward Memorial Hospital, Bombay. From now onwards, I will address it as KEM Hospital. On the night of November 27th, 1973, she was getting ready to go home from the hospital. So she was changing her clothes in a room meant for experimental surgeries on dogs. Suddenly, she was assaulted by a sweeper from the same hospital. He tied her neck with a dog's chain and left her there till she was found by hospital staff after almost 12 hours. When they found her, she was unconscious. The tying up her neck with a dog's chain caused her brain damage as her brain was not getting enough oxygen. Since the tragic night of November 27, 1973, she has remained bedridden. Aruna Shanbaug's treatment was provided by KEM Hospital's nurses. They took care of her like a baby, and none of her family members made an effort to keep in contact with her. In 2009, Pinky Virani, an activist and journalist, filed a writ petition under Article 32 of the Constitution of India, seeking direction for KEM Hospital to stop feeding Aruna Shanbaug in order to exercise her right to die in peace and dignity. In the counter affidavit, the KEM hospital stated that Aruna Shanbaug normally accepts food and responds with facial expressions and sounds. The nurses at KEM hospital who took care of Aruna Shanbaug argued against withholding food since they treated her as one of the family members. The Supreme Court of India appointed 3 doctors to prepare a report on Aruna Shanbaug's health condition. In 2010, the report of the 3 doctors stated that Aruna seemed to be in a permanent vegetative state. She was not brain dead. That's why she was able to communicate using facial expressions and sounds. Now coming to the issues. There were 3 issues in this case. 1. Can a person's life-sustaining system be withdrawn if they are in a permanent vegetative state? 2. Can the person's family members consent on their behalf? 3rd, can passive euthanasia be consented to by the patient themselves? Coming to the decision, the Honorable Supreme Court of India stated that passive euthanasia could be given to a patient under certain circumstances where they have some dreadful diseases. But in this case, since Aruna Shanbaug was not brain dead, stopping food to her for passive euthanasia would be unlawful. The Supreme Court of India issued a guideline that the appeal for euthanasia will be filed in the High Court under Article 226 of the Constitution of India. It is up to the High Court to decide whether euthanasia to be given to a patient or not. Further, the High Court will create a 2-judge bench to review the issue of passive euthanasia with the assistance of 3 reputed doctors. In this instance, the Supreme Court stated that it is up to the KEM hospital to decide whether passive euthanasia should be given to Aruna Shanbaug or not, as they are the ones who took care of her all these years. The hospital denied euthanasia to be given to Aruna Shanbaug. Therefore, the Supreme Court of India also rejected the plea of Pinky Virani, stating reasons that she is not the close friend of Aruna Shanbaug, nor she is her family member. Therefore, she can't consent on her behalf. So her plea was rejected, and on 18th of May 2015, Aruna Shanbaug died due to pneumonia. Thank you so much for watching. Bye-bye.